You're listening to the Conduit to Can Do It podcast, the show that shares riveting, real-life stories curated from startup entrepreneurs and innovators to Fortune 100 corporate leaders who found ways to navigate their path to success. I'm your host, Dennis G. Shaver, founder of Conduit to Can Do It. And you'll hear firsthand accounts how our special guests have turned their bottlenecks into breakthroughs and triumphs, sharing their insider methods, strategies, and roadmaps that will inspire powerful transformations. One key thing I'd like to share with you today on behalf of our listeners is that they're very curious about how they can protect themselves and their idea and not, bank the house, the mortgage on that as well. So can you kind of elaborate on how somebody who has a great idea can cost effectively protect themselves and their idea?
Sure. That's a really great point. I think we encounter often that the initial impressions with intellectual properties, everything has to be really expensive and it takes a really long time. Mm-hmm. And there is some element of truth to that to certain parts, but there are definitely ways to get started that don't cost tens of thousands of dollars and don't take months or years to start the process. Mm-hmm. So that when you're looking at intellectual property, there are types that you're most likely to encounter: trade secrets, copyrights, and trademarks.
Wow, that's a lot.
Yes. So there's a little bit, each are a little different. Some of them overlap, but each can kind of protect you in a different way. So one of the most straightforward protections, or at least the one that often requires the least investment, is trade secrets. Mm-hmm. So if you have an idea that isn't necessarily going to ever become public, you have a formula, like for example, Coca-Cola obviously has a formula for their soft drink that...
Well, I'd love to get my hands on that.
Well, right. What wouldn't a lot of us, right? Yeah, right? But they've kept that as a trade secret for a very long time, and they've certainly spent some money to do so. But at the very basic level, you're controlling who has access to that information and making anyone who does have access to it sign a document that says, I won't disclose this to anyone, and I will only use it in a way, or only use the information I have to further the purposes of the company.
So then a trade secret, is it true that to protect yourself with a trade secret, the trade secret is really not a physical device, it's something beyond a physical device, right?
It can be so it's really anything that has value by being secret. So it can be the information itself, or it can be embodied in a physical product. Mm-hmm. So if you've invented something, pretty much any patent, anything that becomes subject to a patent is a trade secret before it's disclosed. So it can be something that's just in your mind. It can be a formula you write down and you put the formula, the written down part, in a safe. It can be a physical product that you put in a safe. Mm-hmm. It can just be the client list you have because it's important, the contacts that you have to sell your products or anything like that.
So a trade secret really is an idea or a methodology about something.
Really any information that has value because it's a secret.
Mm-hmm. So is that something that a person would file for before they even file to protect their physical invention idea?
The interesting part with the trade secret is there's no registration process. So you're just required to prove that it's kept secret, it has value because it is secret. Mm-hmm. So as long as you can show that you've taken reasonable steps to prevent access to it and to maintain its secrecy, you have protection. Sure. So trademarks are any symbol or words that identify the source of a product or service. Mm-hmm. So for example, Coca-Cola, you see Coke on a bottle, you know what's in the product, you know where it came from. It came from the Coca-Cola company. Mm-hmm. And it can be the words, it can be the Coca-Cola script, it can be in some cases even the shape of the bottle that you know. So anything that identifies the source of the goods or service can function as a trademark.
Okay, so we just got an email from a listener here, and she already applied for her trademark. And she's all excited about it. Looks like she paid about $200 and some for it, for the name. And now she's reaching out and saying, what do I do next? Can you elaborate on this?
Sure. And usually the process will start off with preparing an application that gets filed with the United States Patent and Trademark Office in Washington, D.C., technically Arlington, Virginia, but in D.C. And what that application says is, here is the trademark that I would like to protect. Mm-hmm. Here are the goods or services, or both, that I want to use the mark with. And here, I'm either using it now, and here's evidence that I'm using it now, or I have a bona fide intent to use the mark going forward, and I've taken some steps to do that, meaning I've at least got a business plan together, or I've done some mock-ups or something in the process. So largely what the application does is says, I'm either using it now and here's proof, or I have a bona fide intent to use the mark going forward in interstate commerce. So when the application is prepared, when you're reviewing it, you want to make sure all that information is correct and that you fully understand everything that's on there, and make sure that if you have any questions, you ask either a trademark attorney, or if you're working with a company that's helping you prepare it, to ask them how to do it.
Okay, or also the U.S. Patent Office.
Oh, absolutely, yes.
Yeah.
Well, they can't provide legal advice. They are often helpful in
Guidance.
providing some background information on the
Yeah,
process.
that's awesome. So then, so to get clarity, then, when a person wants to start up a new company, a new process, a new brand, whatever it might be, they have a name,
Sure.
XYZ.
Right.
And if this name has been used by other people in the general public, can you still use that to brand it, or do you have to come up with something unique that's different than anyone that's even posted anything out there about that type of a name? Like, there's certain types that it belongs to as well, or categories.
Sure.
Right?
Yes. Yeah. So ultimately, trademarks are all based on a likelihood of confusion, whether or not consumers in the marketplace are going to be confused about the source of the goods.
Mm-hmm.
So for famous marks like Google or Coca-Cola, they're going to get really wide protection on it, because if you put Google on anything, at this point, most people are going to say that's a Google car. Well, yeah, that probably is made by Google.
Right.
For smaller marks that are only known for one very specific thing, they don't get as wide a protection. So you could have something for mining for oil and something for paper products that could be operating under the same mark. So it's possible to use the same mark for two totally different services or goods by two totally different companies, as long as consumers in the marketplace aren't going to be confused. If you're looking for an extra envelope or some nice stationery, you're probably not going to be confused by the oil drilling equipment sold under the same name. So that's really what it comes down to.
How about the copyright form of protection? How does that? Where would I apply that?
Sure. So, and I didn't mention this before with trademarks, but I should have. With both copyrights and trademarks, to an extent, once you've started using it or created it, you do start getting some protections. With trademark, you get some protection as soon as you start using your mark with your goods or services, even without registration. Always better to register it because the rights are much easier to sort through and much easier to stop other people. Copyright, similarly, as soon as you create anything that's subject to copyright protection, it is automatically copyrighted. However, in order to actually stop a third party from copying and to file a lawsuit, an infringement lawsuit, you do need to get a registration from the U.S. Copyright Office. Trademarks and patents are done by one office, and the Copyright Office is actually separate, strangely enough. And you can submit an application online to the Copyright Office as well. And those applications start as low as $55 a piece. And in some instances, if the work hasn't been published yet, you can actually combine several works together.
So speaking of copyright and protecting rights to the material that we provide, this would be what? A blog, an article, formula? What is it we're copywriting here?
Sure. So the general definition is any creativity fixed in a tangible medium of expression.
So in layman's terms,
but any creativity that you've managed to fix in some manner. You've written it down.
A formula?
Formulas are a little tricky because they're not necessarily creativity in the sense, and there's usually a restriction on copyrights that something strictly functional can't be protected by copyright. You have to go towards the patent side for that, and formulas are actually tricky on the patent side too. But generally speaking, copyrights protect creativity that's non-functional, or at least the non-functional aspects of whatever the creative thing is.
So would that be like a training program somebody puts together?
Yeah, it could be. Now, the program itself or the ideas aren't protected itself, but if you put together a series of videos, the videos could be protected because of the creativity and how you put them together. If you're putting together a packet of information, the text could be protected. If there are forms, those get a little tricky on whether or not they're functional. But generally speaking, if you write a book, if you write a blog article, you create a website, logos can be subject to copyright. You create a sculpture, things like that. And
so then what's the difference between copyright and trademark? Because they almost sound like they're similar.
There is some overlap. So if you create a new logo that's a really cool design and decently elaborate, then you could have it protected by copyright on its own. But it's also possible to also have trademark protection for that logo once you start using it for your product or service. With copyright, there's absolutely no requirement that you use it. So if you make it, you put it in your bookshelf and you never use it again, that's fine. If somebody takes it and uses it, they find it in your bookshelf, they make a copy and they start selling it everywhere, that's going to be copyright infringement, more likely. But with trademarks, you actually have to use the mark in interstate commerce for a particular set of goods or services. And then the ultimate analysis is whether or not consumers are going to be confused between the two uses. So trademark provides a slightly different type of protection. It wants to make sure consumers don't get confused between where the goods are coming from. Copyright just wants to make sure no one copies your creativity. Yeah, trade secrets, pretty much anything that's secret or has value because it's a secret, client lists, formulas, stuff like that. Copyright's going to protect creativity that you manage to fix in some manner, either electronically or written down, or a painting or sculpture, things like that. And then a trademark is pretty much any logo, design, or words that identifies the source of goods or services.
Okay. So I appreciate you sharing that. Now, also, what wise words of wisdom do you have for our listeners in terms of protecting their ideas in whatever form it is?
So I think one of the things I end up asking for people who are concerned about spending the time and effort and resources with IP is, if you had a competitor pop up next door or down the street that's going to offer pretty much the same services or the same goods with similar naming and similar marketing, if they did it tomorrow or 6 months or 2 years down the road, what would you do? So if you're concerned about something like that happening, or if you think it would be detrimental to you, then it's worth considering what the options are for IP protection.
Well, I really appreciate you sharing today, and we must let our listeners know that this is not official legal advice.
Yes, that's good to reiterate. Yeah, no legal advice, just trying to provide some background information. If you are interested in having more information, make sure you contact a licensed attorney.
Right. And then also, this is more about building the awareness and also education so that people are more aware of what's possible and how to navigate the journey of protecting themselves and their ideas.
Yeah, really to make sure that people understand that, there are definitely there's some truth and that it can be expensive and complicated. But there are ways to get started, particularly for new businesses that are cost effective and that can really help you protect yourself and your company for a longer period of time.
Right. Michael, thanks a lot.
Thanks very much.
Appreciate your time today.
Likewise.
Fantastic. Thanks.
Great. Thanks.
There you go. What an amazing talk on a very important topic. It's been my pleasure to share this episode with you, and this is just one example of how you can get one step closer to becoming a conduit to your can do it. Remember, no matter what you're embarking on in life and business, it's really about how you respond or react to everyday situations, and this can help you navigate your way to success. From this day forward, if it is to be, it really starts with you to choose to make the rest of your life the very best of your life. Thanks to each of you for listening today, and if you hadn't had a chance to leave a review on our podcast, we greatly appreciate that as well. That's it for today, and I look forward to our next episode. Till then, onward and upward.